Hello friends, welcome to our informational series. Today we are going to talk about trusts. We will basically cover overview about trust, operations and how to create trust via trustee. To start, let's see what's a trust. A trust is a legal instrument through which property is given in the hands of another person to hold it for the benefit of the third person. The properties belonging to one person are managed by another person for the benefit of the third person. Trust is created through a trust deed. Alternatively, it can also be created through a will. However, a trust created through a trust deed must be written and registered. Trust can be made for any lawful purpose. In case trust is created for purpose of which some are lawful and some are unlawful, then the trust is considered to be for only the lawful purposes. Similarly, if the trust is created for purpose which becomes infeasible or impractical later, then depending on the facts of the case, the same trust may be used for any purpose similar to the original purpose. The trusts can be of two kinds. A private trust is made for the benefit of the persons related to the author. It could be his minor children's or for future generations. A public trust is made for the benefit of the public at large. It could be for the aid of the poor or to provide monetary aid to poor meritorious students or any other purpose. Irrespective of the kind, Indian Trust Act 1882 governs both of them. However, it must be kept in mind that there are different laws governing work, Hindu undivided family, religious or charitable endowments or trust to distribute war prizes. There are four parties involved in any trust. Author, also called a creator, settler, or a donor, can be anyone who is a major and of sound mind at the time of making the trust. In fact, minors or anyone on behalf of minor can also make a trust, but only with the permission of the concerned court. Author is the person who makes the trust for the objectives he desires. A trustee can be any person capable of holding properties. However, if trust involves exercise of discretion, then such a person must be a major and of sound mind. Trustee is the person who executes the trust as per the directions of the author. Property that gets transferred to the trust is vested in the trustee, who is the owner and then applies the same for the benefit of the beneficiaries. Trustees can be one of the beneficiaries but not the sole beneficiaries. It may be noted that the author himself can be a trustee, but then there can be multiple trustees too. Trustee must protect the property of the trust and can be held liable for any losses incurred because of his breach of trust. Usually, trustees are responsible severally and are not liable for the default of the co-trustees, but then there are exceptions and the facts of the cases play an important role in deciding. Trustees do not have any right of remuneration unless the deed provides for the same, nor can they apply the trust properties for their own benefit. Beneficiary or beneficiaries can be any person or persons who benefit from the trust. Beneficiaries can renounce interest by disclaimer addressed to the trustee or by setting up claim inconsistent. Beneficiaries are entitled to all profits and rents from the trust properties. If all beneficiaries are competent and are willing, they can ask the trustees to transfer the trust properties to them also. Beneficiaries have the right to get the trust executed through the trustees and in case of any issue can approach the court. Every trust must have properties which can be movable or immovable. It can be in the form of cash, running factories, or in the form of land or property. It is these properties that the trustees manage for the beneficiaries. Let us see how a trust operates. The day-to-day operations of the trust are performed by the trustees. The scope of their operation depends on the scope defined in the trust deed. Typically, operations would involve operating companies or factories, buying or selling properties, renting properties, or making regular investments. It is always possible that there may come a situation when someone or any of the trustees will have to be discharged. Once accepted, usually the trustees cannot leave the trust except in the following situations when the trustees may be discharged. These situations are by death of trustee, extinction of trust deed, by consent of all beneficiaries, that too if all are competent, by the order of court on making of discharge petition. The trust survives even after the death or discharge of a trustee, and thus there comes a need to appoint new trustees. Other situations where new trustees may have to be appointed are if the trustee is absent from India for more than 6 months or leaves India for residing abroad or has been declared insolvent. Appointment of new trustee is usually done by the author if he is alive or as per the method mentioned in the trust. Usually, new trustees are selected by surviving or continuing trustees or retiring trustees, or in case of difficulties, court is approached by the beneficiaries by filing petition for appointment of trustees. Thou trust can be for perpetuality or as long as the property exists or its objects remain legal or beneficiaries exist, it can be extinguished too. Some of the situations where trust can be extinguished are completion of the purpose of trust, purpose of trust becomes unlawful, fulfillment of purpose becomes impossible, destruction of trust properties by explicit revocation if the trust was a revocable trust. Now let us see how to make a trust deed. Any and every trust deed must contain author details in terms of his name, address, and identity. Next, the name of the trust and its address has to be mentioned. This could be the place from where the trust would operate. List of all the properties transferred to the trust along with complete details in terms of amounts or bank details or the property details should also be mentioned. Object clause covers all the objects and the beneficiaries that the trust is made to fulfill. The object should be written with due care as the trust will only be able to operate within the bounds of its objects. It is advisable to put secondary and tertiary objects so that should any of the objects become infeasible, trust should still be able to carry on. The name and details of the first appointed trustees have also to be mentioned. Trustees within reasonable time can also reject the responsibilities by giving disclaimer, preferably in writing, to the author. Thus, it is better to take prior consent from the trustees before appointing them. Procedure, power, and duties of trustees should be properly enumerated as this will define the workings of the trust. It is advisable to put operations and procedures in sufficient detail so that the trust can work efficiently without any hindrance. Once the trust deed has been prepared, one moves to the next stage of registration, which basically completes the formalities and trust is ready for execution. There are some financial factors that one must keep in mind while forming trust. Trust deeds attract stamp duty based on some percentage value of properties made part of the trust. The amount will vary from state to state, thus the trust must be drawn on stamp paper of appropriate value. The trust deeds also need to be registered and this will attract some registration duty as well, which will vary from state to state again. Other factors to be considered are involvement of legal practitioners or experts, but that we leave to the judgment of the individuals. So this is pretty much the wrap up of the concepts of trusts. Hope we have been able to clarify your doubts. Thanks for watching. Stay tuned.